Welcome everyone to our presentation on Supervisors and Title I of the ADA. My name is Dustin Schwab and I am a Career Development Specialist here at Opportunities for Ohioans with Disabilities, which we refer to as OOD. Today I am co-hosting with my colleague Julie Wood. Julie, would you like to introduce yourself?
Thank you, Dustin. Hi everyone. My name is Julie Wood and I am the Worksite Accessibility Specialist here at OOD. I am also an occupational therapist and an ADA coordinator. One of my roles is to create presentations that are geared toward our employer partners. And today's webinar is focused on the very important role supervisors play in making sure workplaces are inclusive and accessible for individuals with disabilities.
Thank you, Julie. Before we begin, I'd like to mention that today's training comes with the PowerPoint slides, a learner's guide, and a helpful fact sheet. You can access these resources now through the link that is posted in the Q&A section here in Microsoft Teams. Just as a reminder, the information that we share in these resources and during today's conversation is for educational purposes only and is not legal advice, but we do hope this information is helpful for you. We will be stopping about halfway through today's presentation and once more right before we conclude to answer questions. So please post your questions in the Q&A section at any time so that they're ready for us when we stop. Okay, so today we are addressing best practices for supervisors when it comes to hiring and managing employees with disabilities in a way that is aligned with Title I of the ADA, which is the Americans with Disabilities Act. Julie, why is this webinar so important?
Dustin, this webinar is important because supervisors are often not trained on Title I, but they can have a big impact on whether a qualified individual with a disability is hired for the job, remains on the job, and feels included in the workplace. They can also impact whether an employer is adhering to its responsibilities under the law. And that's because supervisors have a role in creating a disability inclusive culture and may assist with establishing qualification standards and essential functions, navigating the hiring process and part of the interactive process, in identifying and facilitating reasonable accommodations, and in managing common situations with employees when disability is a factor. If you don't train your supervisors on Title I, they may feel uncomfortable managing employees with disabilities, and when they don't know the right thing to do, they may not do anything because they don't want to do the wrong thing. So this training is designed to help supervisors feel more comfortable and empowered when addressing situations when disability is involved. And it will help supervisors to know what their role is and when to refer individuals to human resources or HR.
You make some good points, Julie. I was a supervisor in a previous role, and I believe this type of training is helpful because supervisors want to do the right thing, but as you said, they don't always know what that is. And really, you supervise employees with disabilities the same way you supervise employees without disabilities. But we do want to acknowledge that when certain situations arise and disability is a factor, there are guidelines to follow under Title I. So these are important for supervisors to be aware of. Okay, let's begin with creating a disability inclusive culture. Julie, this really starts at the top of an organization, doesn't it?
Yes, the culture of an organization does start at the top. And so if you want to be intentional about creating a culture that is disability inclusive, the best practice is to get support from leadership. And there are many ways to do this, but specific to supervisors, it's important that leadership values the supervisor's role in following Title I and in creating an inclusive culture. Because if leadership does, then it sets the stage to prioritize training for supervisors on how to manage employees with disabilities in a way that supports them to be successful. And this includes training new supervisors as well. One way to create this culture is to provide your supervisors with disability awareness and disability etiquette training. Dustin, you provide this type of training for employers. Can you tell us more about it?
Sure. OOD offers these trainings at no cost for our employer partners, and They're intended to make everyone feel more comfortable and included at work. Our disability etiquette training defines disability, includes practical examples of respectful interactions with people with disabilities, and addresses proper language usage. We can customize training to be virtual or on-site, and we have an on-demand version available on our website. We've included information in the learner's guide on how to contact us to discuss these options and to access the on-demand webinar. So providing disability etiquette and awareness education is a great first step. But another step to consider is how your job's qualification standards and essential functions play a part in creating an inclusive workforce. Julie, can you tell us how the supervisor is involved in these?
Sure, Dustin. Let's start with qualification standards. These are the requirements for the job, like education, experience, licenses, and skills. They're intended to predict or measure a person's ability to perform a certain job. Because supervisors may be asked for their input on a job's qualification standards, it's important for them to know these standards must be job-related and consistent with business necessity when they are applied to individuals with disabilities. Now, this is a phrase you will hear often throughout Title I, and generally, job-related means a standard applies to a specific job, not to a general class of jobs, and consistent with business necessity means a standard applies to the essential functions of a specific job. So knowing this helps a supervisor to make sure qualification standards are written accurately. And this includes making sure they are written in a way that does not limit how an individual can meet the standard, because these can often be met in more than one way. I have an example to share that shows how a qualification standard may be written in a discriminatory way and how to correct that. Let's say an employer requires an employee to have a driver's license to perform the essential function of attending meetings in the public. If a person can't drive because of their disability, this requirement could be considered discriminatory. When reviewing this qualification standard with an inclusive lens, the employer and supervisor could consider other ways to perform this essential function. Instead of driving, the employee could use public transportation to travel to the meeting. As a result, a more inclusive way to write the standard is to require the employee to travel, but not require them to drive to attend the meeting in person.
Thank you, Julie. How are supervisors involved with the job's essential functions?
Justin, the essential functions of a job are the main work tasks and critical duties. Because supervisors may be asked for their input on the job's essential functions, it's important to know how these apply to individuals with disabilities. Title I requires qualified individuals with disabilities to be able to perform the job's essential functions with or without a reasonable accommodation. So it's helpful to be aware that an essential function can often be performed in more than one way using a reasonable accommodation to perform the job just as effectively. And so it's a best practice to write essential functions based on the expected outcome of the task instead of on how the task is performed. For example, instead of stating an essential function is the ability to talk and hear over the phone, state the essential function is to communicate with customers over the phone to exchange information about products. An individual with a hearing disability may achieve the outcome of the essential function in another way, by using a phone with captioning or a video relay service.
That's great information, Julie, because employers hire qualified individuals to achieve outcomes, not to perform tasks in a certain way. This is a great segue to our next topic, which is the hiring process. Supervisors often have a role in identifying and interviewing qualified candidates, and so it's a best practice to inform them of the responsibilities employers have under Title I. This helps supervisors to feel more comfortable in handling situations that can arise when a candidate has a disability and supports a hiring process that is disability inclusive. To help with this, we are going to define disability under the ADA, discuss how qualification standards and essential functions apply to the hiring process, and then address the two phases of the pre-employment process, regarding asking questions and administering exams. Julie, can you tell us what the ADA's definition of disability is? I know it's a legal definition and not a medical one.
That's right, and it can differ from how other laws define disability. The ADA's definition has 3 parts. The first part defines disability as a person who has a physical or mental impairment that substantially limits one or more major life activities. The second part defines disability as a person who has a record of such an impairment. And the third part defines disability as a person who is regarded as having such an impairment. So based on these definitions, people with disabilities are protected from employment discrimination, but so are people without disabilities when they are perceived by others to have a disability. This is important to discuss because while it might not be intentional, hiring professionals sometimes take discriminatory actions when they make decisions based on things like stereotypes, unfounded fears, or things that simply are not true about disability. Or they make assumptions that a person with a disability is unsafe or won't be able to perform the job or will need an accommodation that costs a lot of money. So to prevent this, training is helpful. Like we said before, one best practice is to provide disability awareness education. This can improve the hiring process by making supervisors aware of any personal biases they have towards individuals with disabilities and helping them to feel more comfortable when conducting an interview. This can also help a supervisor to understand that behaviors they may notice during an interview can be a characteristic of certain types of disabilities. For example, a flat affect or decreased eye contact. These behaviors don't mean an applicant isn't interested in the job or engaged with the interviewer.
That's a great example of another way disability awareness education can be beneficial. Now let's discuss how qualification standards and essential functions can support a disability inclusive hiring process and help to identify qualified candidates for the job.
Dustin, as we discussed earlier, qualification standards are often used to predict a candidate's ability to perform the job, and so a supervisor may decide whether a candidate meets these standards before they determine whether they can perform the essential functions. So it's important to inform supervisors that when a qualification standard screens out a candidate with a disability, the standard must be job-related and consistent with business necessity, which again means the standard relates to the specific job and its essential functions. And when the standard is job-related and consistent with business necessity, the employer must consider whether there is a reasonable accommodation that enables a candidate with a disability to meet the standard. Certainly, making the wrong decision here could result in a legal liability for the employer. And while that's important, I also want to note that this decision could cause the employer to overlook hiring a qualified candidate for the job. I have an example that might help to illustrate this. A hiring manager is interviewing a candidate for a job that requires the ability to lift 50 pounds. During the interview, the candidate discloses a physical disability that prevents him from lifting more than 25 pounds. So the hiring manager decides the candidate is not qualified. If the qualification standard is not job-related and consistent with business necessity, then it would be unlawful to use the standard to screen out the candidate with a disability. If it is job-related and consistent with business necessity, reasonable accommodation must be considered. So in this example, a reasonable accommodation may be to provide a lifting device or to permit lifting to be a 2-person task. Again, if reasonable accommodation isn't considered, the employer risks a legal situation and, most importantly, may miss out on hiring a qualified candidate. So to avoid this, make sure your supervisors know how to recognize when a qualification standard is or is not job-related and consistent with business necessity, and when reasonable accommodation must be considered.
That is helpful. What is important for supervisors to know about the job's essential functions when it comes to the hiring process?
Dustin, under Title I, candidates with disabilities are expected to be qualified for the job, which means they can perform the essential functions with or without a reasonable accommodation. Now, to be qualified does not require a candidate with a disability to be able to perform the job's less critical duties, which are known as marginal functions. And that's because one type of reasonable accommodation is to eliminate or swap marginal functions with a coworker. An employer does not have to eliminate an essential function as a form of reasonable accommodation, but they do have to consider whether a reasonable accommodation exists to enable the candidate to perform the job just as effectively in another way. Sometimes we get caught up in thinking there is only one way to do something because that's how it's always been done, or simply because we don't know what we don't know and we can't imagine how else to do the job. So help your supervisors to focus on the ability to achieve the outcome of the task instead of on the ability to perform the task the way it's always been done. And we are going to discuss what you can ask and when during an interview to get the information you need to decide whether a candidate is qualified.
Great. So once a candidate is identified, the pre-employment phase begins, which includes interviewing, testing, making an offer, and conducting any medical inquiries and examinations. Pre-employment is divided into two phases, the pre-offer and post-offer, and the Equal Employment Opportunity Commission, which is the EEOC, has distinct guidance on what can be asked in each phase, as well as for what you can ask when you know a candidate has a disability.
That's correct, Dustin. What's important to remember is that employers are permitted to ask questions of candidates to assess whether they're qualified for the job. There are just certain rules for what employers can ask and when.
Okay, Julie, let's start with the pre-offer phase.
In this phase, you are not permitted to ask disability-related questions or administer medical exams. This is to make sure all candidates are evaluated on their ability to do the job without consideration of disability. So in this phase, employers can ask questions about the candidate's ability to perform the job's essential functions. A best practice is to focus questions on the candidate's ability to do the job and not on disability. So one idea is to have questions pre-written for the supervisor to ask. I have some examples of what you can ask in the pre-offer phase. One is you can ask about the ability to meet the qualification standards, and you can ask about the ability to perform the essential functions, again, as long as they are not phrased in terms of disability. So for example, instead of asking a candidate if they could lift 25 pounds, describe the job task, like moving 25-pound boxes from a skid to a cart that is 36 inches high, and ask the candidate if they can perform this task. If you simply ask if a candidate can lift 25 pounds, the question may elicit a response that reveals a disability. But if you describe the outcome of the task, a candidate with a disability will know if they can perform this essential function with or without a reasonable accommodation. And you can ask all candidates to describe or demonstrate how they would perform a job task with or without reasonable accommodation.
Okay, Julie, what happens if an employer does not ask all candidates to describe or demonstrate a task, but then interview someone with an obvious disability who they think might not be able to perform the task?
That's a great question, Dustin. Sometimes an interviewer knows a candidate has a disability because the disability is obvious, like a candidate who uses a wheelchair, or when a candidate chooses to disclose an invisible disability, like an anxiety disorder. So when you know a candidate has a disability and you can reasonably believe the disability may interfere with or prevent the candidate from performing a task, you can ask the candidate to describe or demonstrate how they would perform the task, even if you did not ask the other candidates. So let me share an example. If you are interviewing a candidate who has one arm for a job which requires moving bulky items from the ground to shelves that range in height up to 6 feet, you can ask the candidate to describe or demonstrate how they would perform this task with or without a reasonable accommodation. Just make sure the question is not phrased in terms of disability and is focused on performing the job task. I know this can be uncomfortable because no one wants to do something wrong by asking a question, but think about it this way. If you don't ask, are you really giving the candidate an opportunity that's equal to compete for the job? If you don't ask, are you assuming the candidate cannot perform the task? And if you don't ask, will the candidate think you are not giving them serious consideration as a qualified candidate? Now, when you ask, if the candidate says they can perform the task with a reasonable accommodation, then either provide the accommodation so the candidate can demonstrate the task or allow the candidate to describe how they would perform the task. If a candidate has a known disability that would not reasonably interfere with performing a task, then you can only ask the candidate to describe or demonstrate how they would perform the task if all candidates were also asked to do this.
Great points, Julie. So in the pre-offer phase, the employer is asking job-related questions to determine the candidate is qualified. What is the post-offer phase and how do things change?
Dustin, a candidate enters the post-offer phase once they have accepted the employer's formal job offer, but before employment begins. In this phase, the employer can ask disability-related questions and require medical exams. The key here is these must apply to all candidates who receive a job offer in the same job category. Now, the employer can condition the offer on the results of these questions and exams. However, if these results lead to not hiring a candidate with a disability, this decision must be job-related and consistent with business necessity. If the candidate is screened out due to a safety concern, the employer must demonstrate direct threat, and there are specific criteria to follow to make this determination. In either case, the employer must consider whether there is a reasonable accommodation available to enable the candidate to perform the job effectively, and in the case of direct threat, eliminate or reduce the threat to an acceptable level.
Thank you, Julie. Employers are required to provide reasonable accommodations for candidates with disabilities to apply for and compete for jobs. What are some examples that may be needed in the hiring process?
Well, when a candidate with a disability needs a reasonable accommodation, what they need is determined on a case-by-case basis. However, I'll share a few general examples with you now, and we do have more in the learner's guide. One accommodation may be to provide written information in an alternative format, such as large print or audio, or provide a scribe to assist with completing forms or taking notes. You may be asked to provide a sign language interpreter or to permit the use of a service animal. And you may be asked to permit additional time to enable the candidate to process a question and then answer. It's important during the hiring process for the supervisor to know how to recognize a request for an accommodation and that confidentiality rules apply when someone discloses a disability and requests an accommodation.
And we will discuss both of those topics shortly. But before we do, let's take our first break to see what questions have come in. Okay, Julie, our first question. So companies provide accommodations for people with physical disabilities. Do you have examples of accommodations provided for those with an invisible disability, such as anxiety or depression?
Sure. So as we mentioned, of course, what a person needs specifically will be determined on a case-by-case basis, but I'll share just some general examples of what an accommodation might look like if a person has an invisible disability like anxiety or depression. One example could be a flexible schedule. A person may need to attend therapy sessions once a week for a period of time, and maybe they need an adjustment to their schedule to be able to leave work early to do that. Another example could be a modified break schedule. A person with anxiety disorder might take breaks throughout the day to manage their symptoms, maybe take some time in a private space to do breathing exercises, things like that. And so those are just some quick, I'm sorry?
You just talked about service dogs too, that
yes,
maybe
yes.
the process might help.
Yeah, service animals can be used certainly with visual disabilities, but also for invisible disabilities as well. So that's a great point. Thank you.
Yeah. Another question, will OOD review our job descriptions to make sure they are outcome-based and inclusive?
Yes, so part of my role is to consult with our employer partners when they have questions about reasonable accommodations and accessibility in their specific environments. So if you are reviewing your job descriptions, I would be happy to talk with you and take a look at those to talk a little bit more in depth about how to write those in an outcome-based way, how to use inclusive language. And so certainly that's something we could work with employers on.
Cool. And then one more question. Who determines if accommodations are reasonable? How is that determined?
Well, that is determined through what is called the interactive process, and that is an informal collaboration between the individual making the request for the accommodation and the employer. And in most cases, that is likely going to happen in your human resources department. That's, again, a case-by-case decision where you look at what is needed, what the cost is, how it impacts your business operations, and that the answer of what's going to be an undue hardship or what is reasonable will be unique to each employer. But it's through the interactive process.
Great, thank you. Looks like that's all the questions that we have for now. Thank you all for your questions, and feel free to type more in the box if you have them throughout the rest of the presentation. So let's discuss the interactive process. Julie, can you tell us what the interactive process is and what is the supervisor's role in it?
Dustin, the interactive process is the informal and collaborative process the ADA requires employers to engage in when they receive a request for an accommodation. The process includes the employer and the employee working together to identify and implement an effective solution. For most employers, this is a responsibility of the HR department. However, supervisors have a role in certain parts of the process, and so we are going to discuss recognizing a request, helping to identify a solution, being a part of the implementation, and monitoring the ongoing effectiveness of the reasonable accommodation. And we will address confidentiality too.
Well, since the process is initiated by a request, let's start there. Julie, does a supervisor need to know how to recognize a request for a reasonable accommodation?
Yes, Dustin, a research study from Cornell University says employees are 60% more likely to disclose their disability to a supervisor than to someone in HR. This is important to know because the employee may also request an accommodation with that disclosure. And we know a request for an accommodation may be subtle. So it's a best practice to inform your supervisors of how to recognize a request because it's likely they will be the one to receive it, and you don't want this to be accidentally overlooked. Here is what the EEOC criteria says about a request for an accommodation. The individual must communicate to the employer that a work-related change or adjustment is needed related to a disability or a medical condition. The request can be made in the individual's preferred form of communication, such as in writing or through a phone call. The request can use plain language, which means the request is not required to reference the ADA, Title I, or the term reasonable accommodation. And a request can be made at any point in the hiring process or during employment, including a performance review, which we will talk about later. So when an employee mentions to a supervisor a barrier to their work or request a change at work and relates these to a disability or a medical condition, the supervisor has just received a request for a reasonable accommodation. It's also important for supervisors to know what steps to take when they receive a request. Now, this often includes referring the employee to the proper contact in HR so HR can continue with the interactive process. So inform the supervisor of who this is so they can communicate this information to the employee. Also, advise supervisors on what to do if they're not sure if the employee is requesting an accommodation. If it isn't clear, inform the supervisor they can ask the employee to clarify what they need and why. In the Learner's Guide, we did reference a website from the EEOC, which provides examples of requests for reasonable accommodation, which may be helpful to share with supervisors.
Knowing how to recognize a request sounds like a great place to start. Now, although HR is usually responsible for the interactive process, there are times when HR may coordinate with supervisors.
That's correct. HR may need to talk with supervisors to help identify an effective solution or to implement the solution correctly, and then to monitor the accommodation for effectiveness.
Great, let's discuss how a supervisor can help identify a solution.
Dustin, sometimes what an employee needs will be easy to determine, but when it's not, a supervisor can help by consulting the job description and describing how the employee is not meeting the performance expectations of the job's essential functions. The supervisor may share what has already been done to help the employee meet the performance expectations, like providing additional training or a mentor. And the supervisor may also help suggest ideas. So this is a reminder of why it's important to write essential functions based on the outcome of a task instead of on the way the task is usually performed, because we know there's often more than one way to get the job done. Encouraging your supervisors to be open to new ideas and informing them of how a reasonable accommodation can enable an employee to perform the job's essential functions can empower supervisors to take an active and helpful role in identifying a solution. To help with this, inform your supervisors of how the EEOC has organized reasonable accommodations into various types, like making the work environment accessible, restructuring a job, permitting a flexible schedule, altering or providing equipment and services, modifying policies, and providing reassignment. And if you share examples of accommodations with supervisors, it can increase their awareness of the many possibilities that exist. For example, an accommodation could be to provide a visual alarm for a baker who is deaf to know when the baking time is up, or to restructure a job by swapping the marginal functions of a job between coworkers. Or you could provide a stand magnifier to enable an employee with low vision to read printed documents.
There really are many possibilities, and I think once you know that, it becomes easier to imagine how a job can be performed just as effectively in another way. The next step is to make sure reasonable accommodations are implemented properly. Julie, what is the supervisor's role in this part of the process?
Well, although supervisors are not permitted to know the confidential information about the employee's disability and the need for the accommodation, they are permitted to know what is necessary about the accommodation to make sure it is implemented successfully. So I have some examples. If a reasonable accommodation involves equipment, the supervisor may need to know when the equipment will be installed and if training is being provided. Because this might impact an employee's workday, the supervisor may have to make adjustments. When a reasonable accommodation includes a schedule change, for example, an employee who is permitted to leave work early once a week for 12 weeks, the supervisor would certainly need to know so they don't discipline the employee for leaving work, and also to make sure there's coverage for productivity or customer service needs. It's important for a supervisor to know when a policy is being modified as a form of reasonable accommodation, so an employee is not disciplined for misconduct. For example, a no food at the workstation policy may be modified so an employee can take medicine as needed with food. And when outside services are provided as a form of reasonable accommodation, such as for American Sign Language interpretation, the supervisor may assist in ensuring the service is provided on time and effectively. Supervisors may also support implementing a reasonable accommodation simply by making sure the necessary steps are completed on time, or by communicating with the technicians who are installing the equipment, or by checking to make sure the accommodation is effective once it's implemented. It's important to inform supervisors on how they can support HR in the implementation process so they understand their role and so the accommodation is integrated smoothly into the workflow.
Seems like there are many times that it is beneficial for the supervisor to be involved in facilitating the accommodation or to be made aware of the presence of the accommodation. What is the supervisor's role in making sure the reasonable accommodation remains effective?
Well, Dustin, first, it's important to know accommodations can stop being effective for a variety of reasons. For example, an employee's disability may change, and this could impact whether a different accommodation or an additional accommodation is needed. Or things can change at work with the job's essential functions, the equipment being used, the layout of the environment, or there could be a change in supervisor. Any of these can impact the effectiveness of a reasonable accommodation, so it's important to monitor the accommodations you have implemented. Now, someone in HR might do this, but some employers may have the supervisor monitor the accommodation. And so it's important to determine this and then advise the supervisor on how to monitor the accommodation. And then advise the employee that someone in HR or the supervisor will be checking on the effectiveness of the accommodation periodically. It's also a good idea to advise the employee to inform the supervisor or someone in HR right away if an accommodation stops being effective, so this can be addressed before it impacts work performance or safety.
Monitoring an accommodation sounds just as important as the other steps in the process because we certainly know things can change. You mentioned a change in supervisors can also impact the effectiveness of the accommodation.
Yes, there can be times when a change of supervisor has a negative impact on the effectiveness of a reasonable accommodation. Now, this may occur because a new supervisor changes or removes the reasonable accommodation intentionally, but this can occur simply because the new supervisor is not aware the employee is receiving a reasonable accommodation because the previous supervisor implemented an accommodation without involving HR and the interactive process. So it's not documented for the new supervisor to be aware of. And maybe this worked well for the employee and the supervisor at the time, but the interactive process should always be followed to protect both the employee and the employer. So it's a best practice to inform all your supervisors, including new supervisors, on their role in following the interactive process with HR to make sure accommodations are documented. And make sure to notify new supervisors of the reasonable accommodations the employees they supervise are using so these employees continue to have what they need to perform their jobs when a change of supervisor occurs.
Sounds like making sure supervisors know to follow the interactive process is key. So we've addressed many ways supervisors are involved, so let's discuss confidentiality because there are important criteria for supervisors to know.
Dustin, you are correct. There are confidentiality rules that apply to the disclosure of a disability and reasonable accommodations, and it's important to inform supervisors of these rules. So basically, the personal and medical information an employer receives must be kept confidential. And this includes the information you receive at any point in the process, from the request for an accommodation through its implementation. The EEOC specifically says this disability-related information must be kept in separate medical files that are stored apart from general personnel files, and the EEOC indicates when certain information can be shared with designated parties. For example, you can share necessary information with employees who facilitate reasonable accommodations for safety purposes or during an emergency. So these are implemented effectively. And you can share necessary information with supervisors to successfully implement a reasonable accommodation. You just want to make sure not to share the confidential information about the employee's disability. For example, a supervisor may need to know about an accommodation, such as a modification to a break schedule. However, the supervisor is not permitted to know the medical information behind the need for the accommodation.
Julie, supervisors sometimes receive questions from other employees about the accommodations they notice in the work environment. How can an employer help supervisors understand how to respond to these questions without compromising confidentiality?
Dustin, because the ADA prohibits employers from disclosing an employee's disability, the supervisor cannot tell the employee their colleague has a disability or is receiving a reasonable accommodation. The term reasonable accommodation is an ADA term, and so telling another employee that their colleague is receiving a reasonable accommodation would automatically disclose the employee has a disability, which is not permitted. The best practice is to inform supervisors of the confidentiality rules and tell them how you prefer they respond, because they will be asked these kinds of questions. The EEOC provides ideas for how to respond, so you may want to review these and customize how you want your supervisors to answer these questions. For example, you could emphasize it's your policy to assist employees who encounter difficulties at work, or you could explain these types of situations are personal and it's your policy to follow confidentiality guidelines. And you can reassure the employee that his or her privacy would be respected in a similar situation.
This is good information for supervisors because they may feel caught off guard when an employee asks about a colleague's reasonable accommodation, and this helps them feel prepared to respond. Now, in general, supervisors manage employees with disabilities the same way they manage all employees. But there are some common workplace situations that can occur, and when they do, supervisors aren't always sure how to handle the situation when a disability is involved.
Dustin, you are right, and these include situations like performance, conduct, and safety.
So most of the questions we receive are about performance, so let's start there. Just as a review, to be considered qualified under the ADA, an individual with a disability must meet the job's qualification standards that are job-related and consistent with business necessity, and be able to perform the essential functions of the job with or without a reasonable accommodation.
Right, so based on this, supervisors can expect all employees, including employees with disabilities, to be qualified to perform the job's essential functions. Part of the supervisor's role is to manage performance, which includes addressing low performance. This is important to do because if you fail to discuss this with an employee, you put them at a disadvantage to improve their performance or to request a reasonable accommodation if that is what is needed to enable them to meet the job's expectations. Now, an employee's disability often does not impact the ability to meet the performance expectations, but when it does, a low performance review may be the first indication to the employee that their disability is contributing.
Julie, so what does the supervisor do when an employee realizes a disability is contributing to low performance and discloses their disability during a performance review?
Because the employee disclosed a disability, you don't want to overlook that, but you don't want your questions to be about the details of the disability. You want to ask the employee in what way the disability is impacting job performance. So a best practice is to focus the conversation on the job and not the disability. The supervisor can do this by clearly communicating the job's performance expectations, the low performance problem, and ways to improve performance.
So the focus of the question related to the disability is on performing the job. Julie, what does the supervisor do if the employee asks for a reasonable accommodation?
When an employee responds to a low performance review by disclosing a disability and requesting a reasonable accommodation, the supervisor should follow the employer's procedures and refer the employee to the designated HR contact to begin the interactive process right away. This is another example of why it's important to train supervisors on how to recognize a request.
And what does the supervisor do if the employee discloses a disability but does not request a reasonable accommodation?
Dustin, if the employee does not ask for a reasonable accommodation, the supervisor may ask what they can do to help the employee meet the performance expectations. Because the employee disclosed a disability, the supervisor can ask if the employee is requesting a reasonable accommodation. If the employee tells the supervisor what would help or would like to explore ideas, the supervisor should refer the employee to the appropriate HR contact to begin the interactive process as they would with any request for a reasonable accommodation. If the employee declines help, the supervisor should provide the employee with the information of who to contact if they decide to pursue options another time.
Julie, a great question we often receive is, what should a supervisor do if they think an employee has a disability that is contributing to low performance, but the employee has not disclosed a disability or requested an accommodation?
Well, in general, the supervisor should focus their questions on the employee's job performance by clearly explaining what performance measure is not being met and what the expectation is. A best practice is to ask the employee what you can do to help them meet the performance expectation without mentioning disability, because it is generally preferred that discussing disability be initiated by the employee, not the employer.
Sounds like it's a good practice for supervisors to focus their questions on the job and ask the employee what they can do to help them to meet the job's expectations. What about the consequences of low performance? Do these apply to an employee with a disability?
They can, Dustin. Reasonable accommodation is prospective, which means it is future oriented. And so when an employee responds to a low performance rating by disclosing a disability and requesting a reasonable accommodation, the employer does begin the interactive process promptly. But the employer is also permitted to apply the consequences that apply to any employee with low performance in the same job class. The obligation for the employer to provide a reasonable accommodation does not require employers to accept low performance, withhold consequences for low performance, raise a performance rating, or assign a rating that does not reflect actual performance.
Okay, so the consequences apply, but a reasonable accommodation must also be considered when it is requested. Now let's talk about conduct. Employers are generally permitted under the ADA to create conduct rules and consequences for misconduct. And employers can expect all employees, including employees with disabilities, to follow these rules. Conduct rules are things like prohibiting violence and stealing and requiring employees to treat coworkers and customers with respect. Julie, what happens when an employee with a disability violates a conduct rule and a disability is not a factor?
In this case, Dustin, the employee may be disciplined with the same consequences that would apply to any employee who violates the same conduct rule. Now, often employees with disabilities do not need reasonable accommodations to meet conduct standards. But when an employee's disability does contribute to misconduct, a reasonable accommodation may enable the employee to meet the conduct standard effectively. As we said before, reasonable accommodation is prospective. And so just like with performance, the employer's obligation to provide reasonable accommodation does not require a supervisor to excuse misconduct or withhold consequences when an employee indicates a disability contributed. However, when a conduct rule is applied to an employee with a disability, the conduct rule must be job-related and consistent with business necessity, and this rule must be equally applied to all employees. Determining whether a conduct rule is job-related and consistent with business necessity is based on considering criteria like the disability-related symptom that is contributing to the misconduct, the frequency of the symptom, the nature of the job, the specific misconduct, and the work environment.
Julie, this seems critical to consider when the misconduct is related to a rule that is ambiguous, like disruptive behavior, because what is considered unacceptable may be unclear. Do you have an example of this?
So to help explain this, I am going to summarize an example from the EEOC guidance about the same employee with the same disability in 3 different situations. Steve has Tourette syndrome, which is characterized by involuntary, rapid, sudden movements or vocalizations that occur repeatedly. In the first scenario, Steve works as a teller at a bank, and his behaviors have caused several customer complaints and are distracting his coworkers. Because Steve's behavior causes him to not be able to perform the essential function of serving customers, and because his behaviors are unduly disruptive to his coworkers, Steve is eventually terminated according to his employer's disciplinary procedures. The EEOC states in this example that termination is permissible because it is job-related and consistent with business necessity to require tellers be able to conduct themselves in an appropriate manner when serving customers, and refrain from interfering with the ability of coworkers to perform their jobs. In the second scenario, Steve works as a teller at a bank, but his behaviors are infrequent and do not interfere with providing customer service and are not disruptive to his coworkers. Now, terminating Steve would be a violation of the ADA because it is not job-related and consistent with business necessity to require Steve refrain from these minor behaviors that do not interfere with his coworkers doing their jobs or with his delivery of appropriate customer service. In the third scenario, Steve works in a noisy environment and does not interact with customers and does not work near his coworkers. His behaviors do not distract his coworkers. So in this scenario, Steve's behavior is not causing him to be unqualified for his job or to be violating the conduct rule of disruptive behavior. So this example shows us what to consider to make sure a rule like disruptive behavior is being applied appropriately and not in a way that discriminates against employees with disabilities. Now, this example did not mention the interactive process or reasonable accommodation. So just remember, when a supervisor is discussing misconduct and the employee discloses a disability, the employer should ask questions to determine if the employee is requesting a reasonable accommodation and ask how the supervisor can help the employee meet the conduct standard in the future. If the employee requests a reasonable accommodation, the interactive process should begin, just like we discussed with addressing low performance.
Okay, before we stop again for questions, let's discuss safety. Employers are permitted under Title I to require applicants and employees not pose a direct threat to health and safety in the workplace. Julie, what is a direct threat?
Dustin, the EEOC defines direct threat as a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. The direct threat standard must apply to all applicants and employees in a specific job class. And if it screens out or excludes an individual with a disability, the standard must be job-related and consistent with business necessity, and reasonable accommodation must be considered. It's important to know that direct threat must not be based on a myth or a stereotype, or based on an opinion or an assumption that someone may not be safe to perform a task. Direct threat must be based on an individualized assessment that includes objective evidence about a particular individual's current ability to perform the job's essential functions. I have an example from the EEOC guidance that includes making assumptions about direct threat. Let's say you are interviewing a candidate who discloses having cerebral palsy, which limits manual dexterity, for a position working in a laboratory. You can't assume the candidate will be at risk of breaking glass containers filled with dangerous chemicals. You must conduct an individualized assessment to determine whether a direct threat exists. I'd also like to mention that employers should take caution with applying any blanket exclusion standards that exclude an entire classification of individuals with a particular disability and prevents the individualized assessment from occurring. It's a best practice to carefully review these types of standards because in most cases, they will not meet the requirements of the ADA.
Julie, do reasonable accommodations have a role in direct threat?
Yes, when the individualized assessment results in a direct threat, the employer must consider whether there is a reasonable accommodation which can eliminate or reduce the risk to an acceptable level.
Thank you, Julie. Let's take one more break to see what questions we have. So I think this first question came before we discussed performance, so it might have been answered, but how do you handle issues that arise after a person is offered a position with an invisible disability and it was not disclosed to the employer prior to employment?
So that's a great question, and it covers kind of a variety of things to talk about. So first off, an individual with a disability is not required to disclose a disability ever. And if they choose to disclose, they can make that disclosure at any point in the hiring process or during employment, including during a performance review. And so at the point that the disclosure is made to the supervisor or to the employer, you would just ask the appropriate questions to understand how the disability is impacting job performance, conduct, or safety, understand what the barrier is. At the appropriate time, hand this off to HR to engage in the interactive process and begin to, in the case of an invisible disability, you could ask for medical documentation to verify the disability exists and the need for the accommodation, and then begin to work with the individual to understand what options there are for effective, reasonable accommodations.
Cool, thank you. So also you talked about a new supervisor coming into an organization, and maybe the former supervisor had been doing something for an employer, providing a reasonable accommodation that wasn't documented. So if I'm a new supervisor, an employee tells me about that accommodation that wasn't documented, should I treat that as a request for reasonable accommodation?
Possibly. I think you want to ask more questions in this situation to understand what the change was in the work environment. And if that conversation leads to some information that may disclose a disability or a medical condition, then you could certainly, either way, probably want to talk with HR to find out if there's an accommodation that's being implemented for this individual so it can continue to be implemented effectively. In the case of maybe the previous supervisor didn't go through the interactive process and just provided the accommodation, then certainly you may want to treat this as a request for an accommodation so it can go through that process and be documented as it should be.
Great. Awesome. Thank you, Julie. And thank you all for your questions. So Julie, I know you have some final thoughts you'd like to share before we close.
Yes, thank you, Dustin. Supervisors have a key role in making sure qualified candidates are hired, reasonable accommodation requests are recognized, and effective reasonable accommodations are implemented. So we certainly hope the information we shared today provides your supervisors with the strategies they need to feel comfortable when hiring and managing employees with disabilities. I want to thank you all for your interest in today's webinar, and Dustin, it's great to co-present with you, so thank you.
Thank you, Julie, and thank you all for joining us.